All the changes. We will speak about just courts because development starts with just justice, and tomorrow there will be some draft laws in the parliament. And but there is a discussion how that could be done. So I hope that today we will discuss that issue, and for our discussion to be constructive, Valentina Simonenko will lead it, and it will allow this discussion to be professional. So I'll give her the floor, and I have a request to speakers because this is a specific issue. Attention to this issue in the Western community is very high. Speak normally for our simultaneous interpreter to translate the essence of your statements. There is one microphone, so if somebody's speaking, switch it on and then switch off when you're done. Good afternoon, dear journalists. Congratulations related to all the holidays. I hope this year will be better than the previous one, and at least I hope that will be calmer, more peaceful. But we need to discuss the judicial reform, and I'm happy to welcome everyone who participated in this, who participates in this roundtable, who would like to discuss these issues, and who is not indifferent to what is happening in courts of Ukraine. I would like to introduce those people whom we have here, and at our roundtable we have first of all, I would like to introduce a representative from the administration of the president as an organization on behalf of the president who brought this draft law to the parliament, and he was heading the working group, and that is Oleksiy Filatov. In addition to that, I would like to introduce Oksana, Syroid, deputy head of the Speaker of the Parliament. Also, we have MPs, one Krulko, built Batkivshchyna faction in the Parliament. I'm the head of the Union of Judges. We have a representative of administration of the President. Miss who knows what, as a judge, what court means, and who was working in the European Court. And also we have Roman Kuibida, who's an experienced person on as a lawyer and a legislator. Also we have Petro Boyko, the head of the Council Lawyers in Kyiv region. And he represents those people who directly communicate with the judges and courts, and the topic of our roundtable. And also we have an MP, Olena Sotnyk, who is interested in this issue. Mykola Kozubra is a representative of a working group that developed the draft law, and Vadim Bilandovich and representative of a law company with Olena partners. And I hope, it seems to me that we'll have a very professional discussion. I would like to draw your attention to the fact that according to we need to discuss two issues during this roundtable. The first one, future Ukrainian judge. Who is that? What is the profile of that person? What, who should be, how the society should see that? And the second issue, independent court, how to provide that. By the way, I believe that Oksana will tell us about that because there was a discussion about the next session of the Parliament of Ukraine. They consider the issue of what they discuss this issue of the draft law, and that is how to provide satisfy the right for the just court. That was the draft law initiated by the President Poroshenko. By the way, the Parliament considers also several draft laws from the Cabinet of Ministers, MPs, and Oksana and Ivanova and Yemets, MP Yemets. They brought them to the Parliament, and judiciary and the status of judges, and one more draft law brought by some Samopomich faction. Now, I would like to give the floor to Oleksiy. Please start a discussion on this issue.
Thank you, Valentina. I would like to start saying that the draft law which was submitted by the President to the Verkhovna Rada, even though it is the initiative of the President, but it's not written by the President. The President set up the Council on Judicial Reforms, the advisory body under the President, which has to develop the strategic directions and the draft laws to implement the judicial reform in Ukraine. Not just the reform of the judicial system, but also the reform of adjacent institutions, without which the reform of judiciary will be impossible in Ukraine. The council was set up in the end of October, and during 3 months they developed a draft law, and the draft law was submitted by the President to the Verkhovna Rada as the draft law of Ukraine. And the council includes the representatives of all the sectors of judicial community. The scientists from leading Ukrainian institutions and universities, practicing lawyers, judges, Ukrainian experts from such organizations as RPR, Mr. Kuibida, Nova Kraina, Mr. Kozlenko, the representatives of the Round Table, of the Council of Europe, of the OSCE. The Council, during 3 months, has developed the draft law, which is focused on the issues of judges, all the issues related to judges. I believe that the results of the work of the Council demonstrate that the main problem in the judiciary is not what types of courts we have, how many types of specialization we have, not what are the rules of judiciary, but it's who are the judges, how the person becomes a judge, how a person develops in the career, how the person is made responsible in case this person commits some violations. So the draft law submitted by the President is concentrated on the issues of selection of judges, of career development for judges, and on the issue of making judges responsible for their actions. We need to understand that the judicial reform is impossible without amendments to the constitutions, but before the amendments are introduced, we have to work according to the constitution. To briefly mention the main provisions of the draft law, first of all, I would like to draw your attention on the issue of selection of judges. The procedure of selection of judges is made public, transparent, and what is also important, there are high criteria for persons who want to get the status of a judge. In the past, when there was a competition for the position of the judge, the candidates that were selected were the candidates who received more points than the average. Now the have to get 75% of points, and so the second is transfer of judges from one court to another. This is very complicated issue because it's not regulated by the Constitution. Now, according to the legislation, current legislation, the judges are transferred from one court to another on the basis of the application submitted by the court, by the judge. And very often the judge requests to transfer him from one court to another because of some family circumstances, and the president transferring the judge from one court to another just has this application from the judge and makes a decision based on his own discretion. Now, taking any position in any court should be done exclusively in the result of the competition. The competition should be organized in a proper way. Similar procedures are applied to the bodies which are to execute control over the activities of the judges. I mean the Higher Qualification Commission and the Supreme Council of Judges. Now they are selected and elected in such a way that delegates to these congresses, the Congress of Lawyers or the Congress of Judges, they can learn about the candidates to the positions at the day of the voting. But according to the draft submitted by the President, such candidates are to be registered in advance. The information about them is to be made public, and all persons who participate in the congresses will have enough time to examine all the information in detail and to understand what candidate is submitted for a certain position. Another issue is disciplinary responsibility of judges. There are two types of sanctions which could be applied to judges if the judge violates the law, and that is the judge could be dismissed or will receive a reprimand. And there are certain bases for these types of disciplinary actions, but according to the new draft, there will be 7 reasons for getting a reprimand, which also the grounds for dismissing the judge are more specific. There are also other important issues in the draft law which is submitted by the President, but I believe that if the moderator agrees to that, I feel that I am taking too much time and I would like to give more time to other participants of the roundtable, but I would suggest during the question and answer session to discuss other provisions of this draft law. Thank you, Oleksiy. I believe that is a very good proposal as to continue this discussion during the Q&A session. Now I would like to give the floor to Oksana Syroid, and she will talk about who is the future judge. Thank you. I would like to start from the beginning.
Задуматися над тим, в Україні не завершиться
revolution of the dignity will not stop in Ukraine until we have a fair and just court, because if you remember the main reflections, what was happening and what was the place of judges of courts a year ago during Maidan, We remember two fundamental human rights that were violated systematically by court, and that was abused human dignity, and that brought us to the streets. And I speak about many rights, but two fundamental rights: the right for immunity, liberty, and many of us were arrested, etc., kept in custody, and fundamental abuse of property right, fundamental right. That was happening for years when Ukrainians investors illegally and as raiders they were taking away the right of property. If you think about these violations, two violations, courts played a key role to limit those two human rights, and that brought to abuse of human dignity, and that was a precondition of those protests, which were called symbolically as a revolution of dignity. That's why without a fair court, we cannot say the revolution is over. What does it mean? Why did it become possible? If we think about that, to the big extent, the courts were playing. They were participants of those process because they were playing in this political process, and that was a part of our, because of our constitution, but because of the bad practices. When the president, doesn't matter who was the president, they and the parliament and committees of the parliament, they had enough of powers. They practiced that political influence, and corruption monitor was in the judicial system was not that bad, but as political. Those political orders, they played the fatal role, and they legalized usurping of power. They neglected the state system, and they neglected the human rights. That's why how critical it is when we move on with judicial reform. How important is it to think about liberation of judges from political influence? Of course, we have some problems in the constitution, but also we can move on to a point, for example, to minimize political influence over judges, and also, or we can enlarge that political influence on them. We need, because the draft law about a just court, a fair court, is not the only one, and it is an alternative to one more draft law, which has a different position. I don't know how many people follow this issue, but this draft law, it started to live in 2005, and it was there were very good intentions and a lot of good mechanism in that draft law. And 2010, when it got into hands of Portnov and Kivalov, only some things were improved. There were some amendments, and as they told us, it meets European standards 90%, and that was to some extent true. But those 10% were fatal. Those 10% of 10% that don't meet European standards, like the system of selection, disciplinary responsibility, just some minor things, but well placed. They caused that problem which we have now. Observing all of that, people who worked on that law in 2005, now we have members of the working group, Mikola and Roman. They are professionals. They started to work on that law in 2005. Then they working on that law in 2011. Now they were preparing as a part of RPR together with the Ministry of Justice. The idea was understanding these awful historic problems, and that we suffered because of political influence of Parliament and the President on courts. We chose narrowing that political influence. Of course, we cannot cancel selection, and we cannot cancel those powers of the parliament or president, but we can make them minimal. We can stop political discretion, and the majority of power should be given to judicial judges, self-governance, and that was the ideology, and those were the ideas we had. And also, we need renovation, complete reappoint, because the majority of judges in the judicial system, they professionally cannot do their work. But we meant all of this should be done by judges, two judges. We need to have judiciary which takes care of the professional standards, which must take care of the independence and political influence. Why is it important? Once again, we need to understand, because some say that we have the war and maybe we should, somebody should control the judges. Maybe we should not set up an independent judiciary because it will become corporate or something. There is a golden rule of power. Powers can be there where there is responsibility. If the president and the parliament are not responsible for courts, and they must not have powers related to appointment, dismissal, disciplinary measures, and everything related to judges. We should use that logic, but have a risk that we will start one more circle, and it doesn't matter whether a year or in half a year we'll face the issue that we'll become hostages of a new influence on judiciary. One more point. We discuss only one draft law prepared by the Council on Judiciary Reform, and which will be brought to the parliament tomorrow to the vote. And the draft law prepared by civil society and registered by MPs were registered much earlier, but until now the committee of the parliament on legal policy and the judiciary has not considered it yet. So that's why the committee has not developed conclusions, though it is absolutely identical. It must be considered, if not earlier, that at least at the same time with the draft law from the president. It's important because it shows the respect and of MPs to their work and to work of their colleagues, and also respect of the president to the work of MPs, and who also work and do their job, and also to civil society, who for many years worked with on how to improve that draft law for that law to meet the needs of Ukraine and Ukraine society. As a consensus, or an effort to find a consensus, is we could, as a base, a committee should consider both draft laws. Draft laws could be taken as basic. Both of them could be taken as basic, both from civil society and also from the president. And in such a case, of those two draft laws, we could develop a consensus, compromising variant which would meet the goal of judiciary reform.
Oksana.
Thank you, Oksana. The fact that we have two laws on the same issue complicates the legislative drafting process. But I believe that we need to move forward and we need to make steps ahead. And probably approving that law, passing that law, will give an impetus to introducing amendments to the law, and will help set up the working group, and this will give an opportunity to make a better law. And I would like to give the floor to myself. I was the member of the council on drafting that law. And I would like to say that not all the proposals of the judicial self-governance bodies, not all the proposals were included because that was a collective body and they would not always agree to the proposals of the judges. But I would like to again talk about who is the judge, whether the judge should be wise, experienced, fair. And I believe that the topic of that round table is to concentrate on these issues, whether by these laws we will achieve the situation when the judge is wise and fair. Can we make the judge approve fair decisions? And I believe I will talk about how we believe the society, judicial society, should be moving. The judges always wanted to be independent, and also we need to discuss what type of a person the judge should be. The judge should be independent, and I agree with Oksana that the judge should be independent from a political influence, from an influence which is applied by some parties using the public. This is now also one of the mechanisms of influencing the judges, but we need to have the judge who is independent. Is it possible reforming the legislation make a judge independent? I believe that the independence is a quality of a person. Can a person oppose any influence? It is his ideas are to be independent, but the legislation has to regulate and to define the guarantees for such an independence. I believe that the direction selected is correct. How can we achieve independence? On the one hand, increasing the disciplinary responsibility and grounds for disciplinary responsibility. On the other hand, we need to take measures which will make impossible any influence. And the law which will be approved in the parliament satisfies the international standards as to the bodies of judicial self-governance. If we compare these two laws, the draft submitted by the MPs has more powers for self-governance bodies. But if we look at the international standards of the activities of the judicial bodies, these documents say that the role and powers of the bodies of judicial self-governance could be defined by the Constitution. Unfortunately, by the Constitution and laws. I believe that without regulating that in the Constitution, it is impossible to achieve the objective that will be set. As to that stage of judicial reform, I agree with both speakers that that is the first stage. And there is a strategy of development of judiciary, there is the strategy of the development of justice in Ukraine, and that is just the beginning of the judicial reform. As to qualification test and selection of judges, and both laws provide for competitive basis for such selection. The international standards also provide for the competition selection according to the criteria defined by the law. Disciplinary responsibility should be also according to the criteria stipulated by the law, and the competition selection should be made on a competition basis. And the criteria of the competition should be defined by the law as well. I believe that passing the law, drafting the law, we have to understand clearly what are the criteria of that competition. The law, this law, and this draft and the draft submitted by the MPs define these criteria. We can discuss it, and I believe the more criteria we have, and the less opportunities there will be to influence such a competition. As to disciplinary responsibility, the basis and this we can argue with the editorial amendments, and this is another issue to be discussed. As to disciplinary responsibility, I like such a basis of disciplinary responsibility as non-informing the council of judges about the influence on a judge. I believe that this will give the judge and the community the protection, not the disciplinary protection, but the protection. The judge can always tell to a person who tries to influence, you? Well, I will be dismissed because you want me to do that. And I believe that at least some law is to be passed just because of that. I've taken a lot of time as a speaker. I'm sorry. Now I would like to give the floor to the MP, Ivan Krulko, who also will join our discussion. Thank you. I am happy that we have this professional discussion on judicial reform, and one of the requirements of the Revolution of Dignity and Maidan was to provide for each citizen of Ukraine the right for fair court, so that the person going to the court understands that his or her rights will be defended there. Now, in Ukraine, we can say that the citizens of Ukraine have very low trust to the judiciary, and that is because the citizens, because of objective reasons, are not sure that their right for fair judgment will be provided or ensured. And I would like to thank the President of Ukraine, because this council was set up under the President, which was working on the amendments to the law on status of judges. I would like to also mention that the civil society worked a lot on these drafts, but besides these two draft laws that we are discussing, there are some other initiatives which are related to the status of judges, as to considering these draft laws in the parliament. And their consideration is timely, but it is important that the consideration of these drafts, the presidential draft law, does not become another parliamentary scandal when the norms of the procedures are not observed, and some MPs may have doubts that the draft laws are considered according to the procedures of the Parliament. Let us look at how the draft laws were registered in the Parliament. There is a draft law 1497 that one of the co-authors of that draft law, I'm one of the co-authors of that draft law. This draft law is not ideal. There could be many questions to that, just as to the draft law registered by the President of Ukraine, 1596. But as a lawyer, as a person who knows the proceedings of the Verkhovna Rada, I can ask why the 1596 draft law is registered like that, because these both drafts are about introducing amendments into the law on the status of judges. We can say that that was some type of a trick, so that another draft is not alternative to the draft submitted earlier. That's not important from the point of view of how it will be considered by the Parliament, but why it was done this way. The second thing, the committee, the profile committee, was considering the draft 1596, but other drafts were not considered. I believe so that it would be correct if other drafts are considered by this committee, and the opinion should be developed also. I would like to remind that when all the drafts on introducing amendments to the draft law on the status of judges, when they are included into the agenda, I believe that all the drafts are to be included into the agenda, and it was mentioned that all these drafts are submitted to the sectoral committee. What will happen tomorrow? Tomorrow we'll be considering the draft 1656 according to the procedure of the first reading. I would like to mention several things, and I would like to say it in advance so that tomorrow there are no problems in the Parliament. Not a single draft could be considered at a shortened procedure, because all the drafts provide for introducing amendments into more than 100 articles, and this should be the full consideration according to the procedures of the Parliament taking place. From the political point of view, the draft law on judiciary and the status of judges, the judicial reform is such an important topic for the state of Ukraine that it should be considered according to the procedure of full consideration. That is one thing. And second, I believe that because all the drafts are included into the agenda according to the decision of the Parliament, they are to be considered in the Parliament together. There should be the report and discussion of each of them, and only after that the decision should be made. I would like to say that because these drafts are not alternative to one another, they are registered. Each one has its own number without additional one, figure one, but I agree with Oksana Syroid that they can follow the procedure that 1496 and 1656 will be taken as the basis, and then one will be submitted with the signatures of all the members, so that all the sound proposals are considered when the draft is prepared for the second reading. Why I am saying that? I'm saying that because I believe we should not, we should be very attentive. Every draft which is approved in the first reading, the amendments could be introduced only to the articles which were voted for in the first reading. And there might be the situation when there are good proposals suggested when preparing to the second reading, they could be approved by the committee, but any MP could put it for confirmation, and they will not get the needed 226 votes. So every proposal should, every draft should take into account all everything good which is in both drafts.
Експерти з реанімаційного пакету
The experts from the RPR, they made their own analysis of the presidential draft. You can agree with some of the provisions are very disputable, but I would like to say that it's correct that we are moving in that direction.
розгляд цього
And I believe that tomorrow's discussion in the parliament will demonstrate the new quality of parliamentarism, which we want to be introduced in the new convocation of the parliament. Thank you, Ivan.
I would like to ask the presenters, the panelists. I have two questions. Do you think that it is a step to strengthen independence of core judges and other emphasis as to criteria of judges? If such laws will be adopted, and what are parts of that law or two laws are such as progressive, as a step forward? Thank you. I didn't want to repeat my colleagues who expressed their position on two draft laws. They developed them. I focused on other procedures that should be considered when we think about these draft laws. But no doubt that those paragraphs of draft laws which are focused on improvement of independence of courts should be supported. That's what Ukrainian society needs. Let's be direct. That not these draft laws, none of them, will make judiciary independent. For the judiciary to be independent completely, there should be political will of all officials who directly or indirectly could influence on the judiciary. It's not. We have corruption in the judiciary not because we have not enough of independence of judges. Even the laws we have that creates enough of independence of judges. But on one hand, judges subdue to influence political corruption. On the other hand, that political corruption is done by other branches of power and not according to the constitution or laws of Ukraine. That's why we can approve a lot, but if we have a political agreement between the president, the executive branch, and the legislative branch and judiciary that the judiciary should be independent, then it will work, and the number of new laws will not influence on that. But qualification requirements, professional requirements there to judges, and introduction of gradation, that's a very interesting opinion. We have to discuss it. And I believe that if judges will be tested additionally, if the professional skills will be tested additionally, that will be very good. It will influence positively on the decisions. Thank you. I always told that I support professional gradations as a way to check judges, to check the professional level. Maybe it's not very popular among the judges, but now, because not all the judges intend to improve their professional level, I believe that such proposal would be very good. Yes. There could be discussion around that, and I'm pleased to give the floor to Olena Sotnyk, an MP. What what is the profile of a judge we should have? Maybe it makes sense to give the floor to representatives of the civic community. But thank you anyways. I would like to go back and I will start from the end. From conclusions, I wanted to conclude that to set up a new system of efficient judiciary and effective judicial branch, we can do it, and not only because of the laws, but because of development of the conditions for the judiciary, under which you can clean yourself, you can show your efficiency, and you could be turned into fair, just court. But it's important to set up preconditions. These draft laws, that means creation of those preconditions, and they will govern the judicial branch. And you as a judges, you must understand that you should be interested that not in some law and or some formal changes or for amendments that for us to protect that we have reform. You must be active. Such if we have 5 draft laws, all of them should be considered, and as a result we must have one. And it will show you that high level you would like to have. Coming back to these draft laws, I am an initiator draft law prepared on the basis of RPR, and it will not be fair from my point of view to speak about only about this draft law. A comparative table, you saw it, a brief one at least, and representatives of RPR will make additional presentation around that. You spoke about the Constitution. The draft law from the administration of the President, it contradicts in some parts to the Constitution. How will we deal with that? The second question, there is a coalition agreement. That coalition agreement was signed by main democratic forces in the parliament, including Bloc of Petro Poroshenko. Nobody says that they represent the president, but this is the force which represent that vector, the vector of the president. So here's the question. This draft law brought her from AP doesn't include principles of the coalition agreement. I would like to remind you, maybe somebody doesn't remember, that it doesn't have such issues like simplification of local self-governance. According to new draft law, that doesn't happen. It's the same like we had before. Second point, absence of political influence. We see that for us not to prevent political influence, it's not, the president would like to strengthen that political influence, and because he would like to influence on selection of judges, to influence on their career, and so that is in fact. That is a presidential influence on the judiciary. Let's name the things they are. And there are some other things like simplification of the judiciary, access to courts, which doesn't happen in this draft law. According to the draft law we developed, all those things provided in the coalition agreement, they are provided and they meet the coalition agreement. And that's a principal issue, because for the parliament, if we united on some principles and we have some agreements, these agreements must be met, or they should be considered at least. Then a procedure, there is one procedure Ivan told you about. You told that let's pass some law and then we'll introduce amendments to that law. Okay. It speaks about double standards. So let's step aside from the law, and I mean the law on the proceedings in the parliament, and then we will pass laws according to the law. So this absence of transparency doesn't create trust in the society to the law we are going to pass. For us to provide some criteria and achievements of the judiciary for them to achieve independence and for them to be honest. First of all, the way the procedures in the law should be honest. So if we have 4 or 5 laws, it will not be easy to pass to approve them because they have different ideas, but the parliament and experts have the right to participate in the process, and as a result we must have that draft law which will create those preconditions for you, because Olena had some ideas about the draft law from as she told from AP. I would like to interrupt. It's not a draft law of AP, and it's not fair to show the situation like contradicting the presidential draft law to the draft law from civil society. Let's be correct to each other. Let's recognize that the draft law prepared by the initiative, but IPR, that is you, but IPR doesn't represent all civil society. Let's recognize that the Council on Judicial Reform includes professionals who have representative. They represent different sectors, including civil society and legal society. Also, I would like to mention that it's also not correct to say that the draft law developed by the Council on Judicial Reform doesn't meet a coalition agreement. Those regulations, those parts which were mentioned by the previous panelist, I would like to say, as to simplification of judicial judges, Salganas, we have it, and there is in the draft law when it was developed, it considered about 60 comments and recommendations of the Venice Commission and Consultation Council of judges and other international organizations. As to the absence of political influence, I hope that maybe there will be more time of all stakeholders to read the draft law developed by the Council on Judicial Reform and to see that there is no strengthening of political influence of the president in this draft law. Any decision of the president is done only to formalize decisions which were made by courts, self-governance bodies, by judges. If we speak about appointment of judges, about moving them to other courts, the president takes decisions only when there was a transparent competition. A candidate confirmed that he can hold that position. High professional commission makes a decision on whether that candidate is good for that position, and then they give that decision informally on the decision the president of the parliament. The same about bringing to criminal to disciplinary responsibility. As to better access of citizens to courts, the draft law pays a lot of attention to that, and that all court meetings are open. The law prohibits to have any obstacle to court court meetings. The law introduces a complete openness to court decisions. Any citizen can freely get information on any decision, and this should be through internet. Prohibition or exception to some decisions that should not be there, they're excluded by that law, in difference to the situation which we have now. Thank you. Thank you, but we overuse our time, so I invite our presenters to focus on the topics. We have an issue of what profile of a judge, what kind of a judge we would like to have, and also a principle of independence. I would like to give the floor to Igor Oleksiy, who decided to participate in our work. Thank you, dear colleagues. In your question, I would approach broader. When we discuss the judicial reform, we should not give an answer what kind of a judge we would like to have. I would like to ask you, as a result of this roundtable, ideally, the draft law in the parliament, we should resolve the issue of the judiciary system in general, because the status of a judge and the issue of his or her disciplinary responsibility and the issue of professional criteria, so those are important, very important, but that is just one part of a transparent judiciary. That's why when we speak about
When we are talking about what legislative amendments should be, we need to understand that the status of judge is one thing, but we also need to remember about simplification of procedures and other things. We have the benchmark, which allows us to submit amendments. That is the current constitution, and everything we can change in the regulations, in the codes of procedure, as to ensuring the independence of judges and providing additional guarantees to the participants of the process, providing them more transparency and efficiency. That is the framework that should be present in the context of drafting these laws. And I wouldn't agree with you that to draft laws, that's complicated. To draft laws is good. Basically, there are more than two of them. There are 5 of them. And during the discussions in the parliament, we need to step away from what is the number of the registration number of the draft, who's the author. We need to understand that the law should be for Ukrainian people. And I'm sure that this is the only chance for the parliament to implement the judicial reform. If, in the result of the presentation of these laws, saying that this is the judicial reform, if we pass the law which will not introduce any qualitative changes to the system, then I believe this country will never have another chance to implement reforms. When we are discussing these drafts, it's good that there are several drafts. Each of them is good, but there are certain reservations in them. Certain drafts have some type of provisions, but others have different provisions. So the draft drafted together with the RPR, and the Ministry of Justice participated in that, and that is introducing electronic judiciary. That is the correct step. And we need to implement it right now. And there are many other initiatives. I believe it is good that there are several drafts. We need to respect the right of the MPs for legislative initiative, and I believe that the Committee on Judiciary should become the platform which will give birth to joint draft, which will include absolutely all the comments and will create the foundation or preconditions for implementing a high-quality judiciary reform. And then the citizens will again start trusting the judicial system. Assessing the draft of the presidential administration, I can say that there are good ideas there. They are to be implemented into the joint draft, which will be developed by the